Last speaker for this session, Jen Jude. Where's Jen? Jen's a senior assistant attorney general, and we'd like to have her come up, and she's going to talk about some of the recent Supreme Court decisions.
Thanks, Scott. Hello. So I'm just talking about, as Dick said, the recent Supreme Court decisions. There were 11 in 2013, and those are the ones I will be going over today.
A little closer, Jim.
I am sure many of you in the room were involved in these cases and have a deeper understanding than I do. My presentation is not intended to be an in-depth legal analysis of these cases. Really, I just want to hit the high spots and make sure and make people aware that these cases are out there, and maybe if you have issues related to some of the topics in those cases, that might make those cases a read. Okay, so here's the list, the overview of what I'll be talking about today. Early in the year, we have the Sedalia case. That, of course, has been mentioned a few times already today. In March, there was the Wolf versus Putnam. That was an abandonment matter of Division 1. In April, the CWCD had a dispute flow case with a decision from the Supreme Court. Also, Division Engineers had an abandonment matter decided in April. Then we have the East Cherry Creek Valley Water and Sand District case. I think people refer to that one as the Colorado Water Network case. Town intern probably won't have much ability to name the cases we work on. And November, the Rivian versus the Colorado Water Commission case. Okay.
You got it upside down.
Is that the problem?
There you go.
Okay. Sorry about that. After the water network case, Freeze versus Tidd, Upper Black Squirrel versus Cherokee, and the St. Jude's case, and then these court cases that I already went through. Sorry about that. Okay, the Sedalia case, probably shouldn't spend too much time on this. My guess is that everybody's probably generally pretty familiar with this. This was a change of water right for a portion of the Ball Ditch water right. There had been a previous change, a couple of previous changes actually, and since the last change of the water right, there had been 24 years of non-use of the right, and that was uncontested by the parties. At issue in this case was whether we would apply the HCU determination from a previous change case to the current change, and whether or not you need to consider zeros in your HCU analysis for any years of non-use as a change circumstance since that previous change. The water court held that the amount of HCU carried over in the change could not be relitigated after the previous change. Issue conclusion applies, and therefore the amount available from the previous change was fully available for this new change. The water court also held that instead of zeros for years of non-use during the HCU analysis, really what we should be looking at is abandonment, whether or not that water right had been abandoned. The Supreme Court, engineers appealed the decision of the water court, and the Supreme Court agreed that issue conclusion applied to the HCU analysis prior to the last change, but disagreed that issue conclusion applied after the last change, and that issue conclusion does not prevent inquiry into years after the previous change. What slide is this on? 7?
I don't know.
Excuse me. That prolonged non-use calls into question the appropriate representative period of time. This is my first PowerPoint presentation. Welcome to the 1990s, right? Okay. The water court held that they must determine whether a revised representative period for calculation of the amount of HT water available for the change of water right is warranted. And this this case is of course now moot because of the passage of Senate Bill 15-183, which is now codified at 3792-305-3D. So after water rights been changed, HT was set, and as you can see, it says that once it's set, the water judge shall not reconsider or requantify the historical consensus. Second decision issued last year is the Wolf versus Jim Hutton Educational Foundation. This is a Division I abandonment proceeding involving the Tip-Jack Ditch water right. The water court found that the point of diversion for the subject water right had never been used to divert the Tip-Jack water right. But even with that finding, held that the engineers had not established the presumption of abandonment. And they also held that the State Division engineers had not established by a preponderance of the evidence that the applicant had failed to use the water right. The court further held that even if they had established, even if the engineers had established this presumption of abandonment, the water user had rebutted that presumption. The engineers appealed that decision, and the Supreme Court disagreed with the lower court and said that because the engineers were able to show that the users failed to divert that water right for at least 10 years at the decreed point of diversion, the engineers had in fact established a rebuttable presumption of abandonment. The Supreme Court was clear that the burden then shifts once that presumption is established. The burden then shifts to the water owner to establish that there is excusable non-use or otherwise a lack of an intent not to abandon the water right. And then showing those things would then rebut the presumption of abandonment that had arisen. Supreme Court said that because the water court erroneously believed that proof of non-use of the decreed point of diversion for 10 years or more was insufficient to raise a presumption, it failed to require evidence excusing such non-use in order to rebut the presumption. So the matter was then kicked back to the water court after reversal of decision to on remand to consider whether or not the applicant had met their burden of rebutting the presumption of abandonment. On review, Hutton was able to rebut the presumption and the water right was not abandoned, but at least they got the procedure right. Okay, the next decision on the list is the Colorado Water Conservation Board San Miguel River in-stream flow water right application. This is a Division IV case concerning the nature of the CWC proceedings to appropriate, decision to appropriate an in-stream flow right. A motion for determination of question of law was filed in the case as to whether or not these proceedings are quasi-judicial in nature or quasi-legislative in nature. The objectors in the case argued that the proceedings were quasi-judicial in nature and that certain due process requirements that would go along with a judicial type proceeding were not met. I think what they wanted in this case were things like cross-examination, the ability to cross-examine during this hearing of the CWCB rules. They wanted resume notice of the proceedings, and they wanted in general more review of the CWCB's process. It just amounts to a heightened standard for the procedure and the decision-making process for the CWCB. The water court held that in this decision-making process of the CWCB to decide whether or not to appropriate the in-stream flow, that they're acting in a quasi-legislative manner and not quasi-judicial. The basis of the decision is that the CWCB's in-stream flow appropriation is legislative or quasi-legislative because it's a policy decision to preserve the natural environment on behalf of the people of the state of Colorado. All right. And as opposed to an adjudication of rights or duties or obligations of any specific party. We were talking about something that's more judicial in nature than legislative. When it's going on within an agency, they're typically taking away or at least dealing with specific rights of an individual party. And they have to have, that party needs to have processes available to them in order to adequately protect their rights and make sure their concerns are heard. So that was appealed to the Supreme Court, and the Supreme Court upheld the water court and agreed that this process and the hearing process that the CWC has to decide to appropriate in-stream flow is, by its nature, legislative, quasi-legislative, and not quasi-judicial, and agreed that in making a decision to preserve the natural environment for the people of the state of Colorado, the focus is on not on the rights of any identifiable individual or entity. So although there is a hearing that the CWCB holds when they are making the decision whether or not to appropriate, that's their process. It doesn't necessarily mean acting in any kind of quasi-judicial manner, and certainly there is no one particular interest that's being potentially affected in the kind of process. McKenna versus Woody, issued in April of last year. This is a Division II decennial abandonment listing. This water right was placed on the list because the diversion structure was silted in, there was no head gate, there was no pipeline from the new diversion structure to the original ditch. The bed of the ditch, I believe, was some 4 feet above the river, and the owner needed to get a change of water right from the new diversion, that new diversion structure to the ditch, and that it never occurred. Based on the facts, the court found that there was sufficient evidence of non-use to create the presumption of abandonment. And the court also made some findings, or I guess confirmed laws about self-serving statements not rebutting the presumption of abandonment, and claims by the user that they don't want to lose the water right don't amount to an intent not to abandon. There was also an issue in this case about the division engineer's compliance with the abandonment statute 3792 4011A, an allegation that he missed the July 1 deadline to prepare the list. I don't think that there were any real factual findings on this issue. I think what had happened was that this question was raised in the closing brief at trial, although I'm not confident about that. But there were factual findings in the record that McKenna had notice of the list at least as of July 28th, so almost a month after the deadline. But in any event, on that issue, the Supreme Court did hold that the preparation deadline is not mandatory as long as the owners of the water rights involved are protected. So it's not something, if that notice, if that list isn't created, issued by July 1st, the water court doesn't lose jurisdiction over the matter. It's just a procedural mistake, and if it doesn't harm the owner of the water right, certainly no harm, no foul kind of situation. Here, because McKenna, the owner of the right, did get notice in July and filed a timely protest to the abandonment list, there was no prejudice. The specific language they used is that the deadline to prepare the abandonment list under 3792 4011A is directional and not a jurisdictional mandate. And then the Supreme Court also upheld the abandonment of the water right. Next up, East Cherry Creek Valley Water and Sand District versus Greeley Irrigation Company. What I can refer to as the Colorado Water Network case. It involved change of shares of the Greeley Irrigation Company. In this particular case, there was a previous change that involved a ditch-wide analysis in a prior case. It was a 1998 ditch-wide analysis, or at least the change was 1998. There were changes that occurred after the ditch-wide analysis, but previous to the subject case. And the applicants in the subject case wanted to be able to rely on the ditch-wide like those other change cases had that came before this particular change. So the applicants filed a motion for determination of question of law on the issue of claim preclusion and whether the ditch-wide analysis applies to change of law rights in this case. There's also a question of who has the burden of establishing claim preclusion through a showing of no change circumstance. The water court found that if subsequent events exist that were not previously addressed by the court, and those events are germane to injury, then the HCU quantification from 1998 is subject to requantification. The court held that it's the applicant's burden to prove that the results of that ditch-wide were in fact applicable to this case, and you can carry those numbers forward. Oops. The water court on applicant's motion certified the order on the motion as a final judgment, meaning that it could now be appealed. So the applicants then appealed the ruling that pertained to the HCU analysis from the ditch guide. The state division engineers cross-appealed, claiming that the order on the motion for determination of question of law didn't constitute a final judgment that could be appealed. The Supreme Court agreed with the engineers that they really didn't have a final ruling from the water court. The rule is that the water court can only enter final judgment certification if an entire case or an entire claim for relief has been resolved. So I guess only if an entire case has been resolved, or only if an entire claim from a case has been resolved. It's okay if there's one claim among many that's been resolved and there's still some unresolved claims, but you do have to have a claim for relief that's been resolved. It can't just be an argument made within that claim for relief. I think when we look at this, is that what happened is the water court sent this case to the Supreme Court for determination on this one particular legal question of whether or not the HCU analysis applied, but the Supreme Court said without an entire claim for relief being resolved can't be appealed. You need to go through, litigate the entire claim, and once you get a decision, if you don't like it, you can appeal at that point. Oops. Freeze versus TID. This is probably a pretty factual, discrete case, although really pretty interesting. I don't imagine we'll have much general application. It was an application for a hydropower water right from TID. And TID owned land, and Freeze, the other party in the case, had an 1890 water right running through the property that was diverted off Garner Creek and through the Garner Creek ditch number 1. TID claimed this 2010 non-consumptive hydropower right through the same headgate and through the same ditch, but I believe the facts were that once it was diverted into the ditch, he then had to divert it further away to use it through his hydropower facility, and then brought it back to the ditch where it used to run before Freeze ever needed to use it for irrigation. The water court entered an order finding that TID can open the ditch for hydropower use as long as it doesn't adversely affect Freeze use of the water under their senior water right, and they included a number of terms and conditions in the decree to prevent injury. Freeze appealed the water court determination that TID can run a portion of his 2010 water right under the 1890 priority at the head gate. and then apply it to their hydropower facility before letting him use it. The Supreme Court upheld the water court, and in doing so focused on the public nature of water to the stream, the right to apply water to beneficial use, and the goal of maximum utilization. Citing an older St. Jude's case, the Supreme Court noted that the owner of the property burdened by a ditch easement has no right to alter the easement without consent of the benefited owner, unless he or she first obtains a declaration by the court that such alterations will not cause any damage or injury to the user of the easement. And since the water court had made that determination, the Supreme Court believed that was sufficient. The Supreme Court also made a finding that TID didn't affect TID's use of the water didn't affect the freeze use of their 1890 irrigation right. The freeze had claimed it was an actual change of their water rights since they were diverting it under their priority. But both courts disagreed, and so although the hydropower right was using the same point of diversion and some of the same physical water as the freeze, the court said that this sort of thing is not only permissible, but that Colorado law favors multiple uses of water if injury to senior rights will not occur. But there was a dissent by Justice Marquez that was interesting, and she noticed that the TID hydropower right relies entirely, and actually couldn't tell from reading if it was entirely or just for the most part, if there was some portion of the junior right that was actually diverted under their 2010 priority. I didn't think there was, but maybe. So she said because this junior right relies entirely or for the most part on diversions under the 1890 water right, that this kind of thing was troubling, she called it, and troubling that a new junior appropriator would be able to divert under the 1890 water right. She said such an arrangement doesn't meet the requirements of new appropriation, that under the Constitution, a right is recognized to appropriate unappropriated waters of the state, and that's not what TID was doing here. So I'm not sure about the details in this case exactly correct, but that's the essence. But you know, you have a junior water right, and you're wanting to divert into more senior priorities, might be a good week. Upper Black Squirrel Creek Groundwater Management District versus Cherokee Metropolitan District. This is a case involving designated groundwater, but really it's mainly a question of contract interpretation. The Division 2 declaratory judgment action stemming from a 1999 stipulation between the two parties, CBS and Cherokee, and whether certain language in the stip requires that Cherokee recharge the basin with effluent from their wastewater treatment plant, or whether Cherokee can use that water as a source of replacement water in their replacement plan that was pending from the Groundwater Commission. The question first went to Judge Mays, who I believe found that the wastewater treatment plant effluent couldn't be used in the replacement plan. And then the case had some procedural wrangling where there was a new party jumped in. So the question again before the court, because there was a new party involved, but this time it was Judge Schwartz. And he found differently on the same legal question. And he said, the 1999 stipulation does not prohibit Cherokee from claiming wastewater returns as credit for the replacement plan, even though wastewater is being returned to UPS as recharge. This was appealed by the Management District, and the Supreme Court upheld the decision of the Water Court, saying that the effluent can be claimed in a replacement plan, but the decision, I would say it's pretty murky what they're really saying in the decision. I mean, they did say the decision was upheld, and they said that Cherokee could claim the use of this water in a replacement plan. But there's language in there that makes it sort of confuses the issue as to what they're really saying. I read it a number of times, so I'm sure I'll read it many more times before it's back down from the Groundwater Commission. St. Jude's versus the Roaring Fork Club. This is an appeal of a water court grant of water rights to the Roaring Fork Club for 21 CFS through the Roaring Fork ditch, which is a ditch that runs through the Roaring Fork Club property, and effectively creates sort of this private stream for the club. The water rights claimed for the uses claimed for the water right were aesthetic and recreational amenity to a golf course and fish habitat for a private fly fishing stream. When that water right was granted, St. Jude's, who's the neighbor to the club, appealed. The Supreme Court reversed the grant of water right and held that the claimed right failed to meet the definition of an appropriation. That is, application of specified portion of water to the state to beneficial use, because they held there was no actual use by the club. The Supreme Court further stated that uses are passive, meaning they're not active uses, and that in order to be a beneficial use, you must have objective limits beyond which the use is wasteful. And they stated they didn't occur here. And the Supreme Court also talked about subjective enjoyment and considered the highly regulated nature of the recreational in-channel diversions and in-stream flow rates, and said that the amount of water necessary to efficiently produce beauty, excitement, or fun cannot be quantified. And therefore, when these kinds of subjective experiences are recognized by the legislature as valuable, it has specifically provided for their public enjoyment, scientific administration, and careful measurement, and then they cite to the in-stream flow and RICD statute. So, where these uses are allowed, they argue the legislature has specifically given processes that the agencies have to go through, or the municipalities have to go through in order to acquire these water rights, but short of that, at least these applicants didn't put a number on it. The court stated, without describing a purpose for the accomplishment of which a measurable amount of water, however approximate, must be used, the club, by definition, fails to articulate an intent of the specific amount of water it claims beneficial use. So, this case is recommended read if you're claiming a water right, especially a direct flow right for aesthetic, recreational, or piscatory use. This is a Division 3 case, Office of the State Engineer's approval of the plan of water management versus Special Improvement District Number 1. Worried I may not give this case justice. I don't really speak the Division 3 lingo, but this case stems from a plan of water management by the Special Improvement District Number 1, referred to as the sub-district of the Rio Grande Water Conservancy District. It was decreed in 2010. The court referred to the plan of water management as the amended plan in 2001. This amended plan is an effort by the water users in the San Luis Valley to regulate water levels and protect senior service rights. It's an effort, it's a self-regulation mechanism, I believe, using economic-based incentives to promote reasonable use and management of irrigation water. The plan of water management, or the amended plan, requires a sub-district to prepare annual replacement plans and then get the state engineer's approval of these replacement plans every year. So this case arose from the 2012 replacement plan. The objectors had a number of challenges that were heard in motions, and then there was a 2-day hearing on the matter. And I know there were some important findings, and I don't need to gloss over them. But some of the challenges they made, the courts decided that they had already been appealed and therefore couldn't be considered by the water court. And the objectors also argued that the annual replacement plans are such an integral part of the plan of water management that in order to talk about the replacement plan, we're going to go back into the actual original case, but the courts disagreed with that. The courts did agree that it was okay to use closed basin project water for augmentation use. That was consistent with how that water is decreed. And then there was a question about treatment of dog wells. The court found that the way the replacement plan dealt with dog wells was appropriate. This case is probably not worth spending much time on. It's a town of intern case, and there was a non-attorney pro se trustee who was attempting to represent the trust in a water litigation or a water court case, and the water court said that pro se parties can't represent other parties in litigation. Told him to go get an attorney, and he disagreed that he had to. But the Supreme Court upheld the decision of the water court and said that even if you're the trustee of the trust, you can't represent other people as a non-attorney in the water in any kind of litigation. Okay, last case on the list is the Meridian Service Metropolitan District versus the Colorado Groundwater Commission. This was an application in Division 2 Water Court for surface water rights, but it was within the geographic boundaries of the designated groundwater basin, the Upper Black Squirrel Basin. After it was filed, objectors argued that the Groundwater Commission first needed to review the case to determine whether or not any designated groundwater was implicated by the application. The Water Court agreed, and so the case was kicked over to the Groundwater Commission, who, after hearing, did determine that some of the water that was the subject of the application is designated groundwater. That was appealed. The District Court agreed with the Groundwater Commission, and the Supreme Court affirmed. Specifically, the District Court found that precipitation that falls in the designated basin would sink into the ground and be part of the groundwater supply, but for Meridian's development. And it's that water that would normally not be not be visible on the surface under natural conditions that is designated groundwater, not subject to adjudication under the 1969 Act. The District Court also found that water Meridian sought to divert under their water court application was runoff that had been increased by Meridian's construction of impermeable surfaces. The Supreme Court agreed and found that both of these findings were amply supported in the record, and they affirmed the decision of the water court. So both before the Groundwater Commission and District Court, the parties didn't talk about numbers, what amount of water that's the subject of the application is designated groundwater. That wasn't discussed. The case was remanded for further proceedings, and I anticipate that's the next step in the Meridian's process. But I think this is a really important case for surface water applications within the geographic boundaries of a designated basin, especially if you're in the Upper Black Squirrel. Those are the cases. Thank you.